Good morning.
Yes, good morning. I guess we again had some issues with with the broadcasting platform, but we should be okay. We are now live because we're going through Zoom instead of restream directly. I had to use that channel.
Good morning.
Yes,
Yes,
can
good
you hear
morning.
me?
I guess we again had some issues with with the broadcasting platform, but we should be okay. We are now live because we're going through Zoom instead of restream directly. I had to use that channel. Good morning. Yes,
Yes,
can
good
you
morning.
hear me? I guess we again had some issues
Let me
with the broadcasting platform,
just
but we should.
yes.
I had to use that channel.
Okay. Can you please tell me if you hear me?
Yes.
Okay. So to our audience, again, apologies for the technical issues. I mean, that's not the first time, unfortunately, we have them. Um, if you just give me one more second. We should start in a minute. Okay. All right. I think we're fine. With all the channels. So we are streaming here on LinkedIn, on YouTube, whichever works best for you. I'm talking about our audience, of course. Just one more second. Okay. Okay. Well, this is, I believe, our ninth webinar, open conversations about Interpol abuse. And today we usually have lawyers practicing in this area joining me, but today I'm delighted to have Edward Lemon and Giulio Calcara as my co-panelists. We're going to be talking about Interpol abuse from a scholar's perspective. Dr. Lemon has devoted a lot of his work to Interpol abuse, and so has Dr. Kalkara. We will be talking about their work and how they see the issue developing again from a scholarly standpoint rather than a legal standpoint. I will let you choose who's going to go first. I guess, Julie, do you want to go first? Because I believe you prepared a presentation on Taiwan, among other things. And then if the audience has questions, please feel free to pause them. We'll be happy to answer them in the Q&A part.
I can start if it's fine with you, Edward, as well.
Yes, of course, yes, please.
Thank you very much. So, as we discussed, I wanted to present something that I've been working on for some time. Maybe it's not entirely connected to the issue of Interpol abuse. However, we're talking about essentially the health of the international organization, and I thought this was an interesting aspect to bring to the fore for the discussion. So I wanted to talk about the concept of membership inside of Interpol. And I'm going to talk about the concept of membership inside of Interpol by taking the example of Taiwan and its exclusion. So we're going to look a little bit at the history, but that's important because by looking at the history, we can find some incongruences with the present and some legal issues that are still going on. Is my audio fine? We didn't get the chance to check. I can't hear anybody.
I can hear you fine. I muted myself.
Okay, thank you very much. Yes, so I prepared a few slides, and I'm going to try to share them. Please let me know if this works correctly. So I'm just going to try just to share. You have to authorize me to share stuff. Okay, good. So why did I think that this was an important topic about assessing the concept of membership? I think this is a very interesting topic because, and I'm trying to minimize you so I can see my own slides as well. The process of admitting and excluding members is closely tied to the principle of democracy within international organizations. So the way that the procedures, the way that the laws are respected in the context of who is a member and who isn't, who is allowed to participate and who is excluded, that kind of gives us an idea of how strong is the democratic principle inside that specific organization. And it's a good starting point is to look at the constitution of Interpol. What does it tell us on matters of membership? So membership of Interpol is something that there are many sometimes debates who is or what is a member of Interpol. So let's start with the Constitution of Interpol. It's the Constitution from 1956. It's still the same Constitution, of course, with some amendments. Article 4 has remained unchanged since 1956. So Article 4 tells us that any country may delegate as a member to the organization any official police body whose functions come within the framework of activities of the organization. The request for memberships shall be submitted to the Secretary General by the appropriate governmental authority. Membership shall be subject to approval by a two-thirds majority of the General Assembly. Now, something should give us pause immediately. So Article 4 of Interpol Constitution does not use the term state, which is a specific term in public international law. It refers to sovereign state in general, but explicitly refers to country, which is a much less defined concept of international law. So the difference between state and country has a great significance. Let's actually see what, at the moment of drafting of the Constitution, what kind of debates were ongoing, because we have evidence of that. So the term state was deliberately omitted from an early draft of Interpol's 1956 Constitution. So there was debate, should we use the word state or not in the Constitution? And it was deliberately omitted. And why? We can see some debates that wasn't going on at the time. The Indian delegation emphasized that non-autonomous regions also needed to combat crime, and this was why their membership was valuable as well. The Dutch delegation agreed, noting, for instance, that the Netherlands, Antilles, and Suriname were at the time members of the International Criminal Police Commission, which is what Interpol was called before 1956. There is an instance, and only one in the Constitution of Interpol, where states are mentioned, and that's on Appendix 1, where is a list of states to which certain procedures apply. But among the list of states, there is also the Netherlands Antilles, which is not universally recognized as a state. So that does not essentially overrule the provision of Article 4, I would say. So it's safe to say that the intent of the drafting committee was that territorial entities with independent policing constitutions were recognized as countries for the purpose of joining the organization at the time when Interpol constitution was adopted in 1956. Now, Interpol, there have been many attempts from the late 1980s onwards, which is a very close time on when we're going to look at some events that have happened concerning Taiwan. So the timeline is not coincidental. So there has been very attempts from 1980s onwards to amend the Interpol constitution and to officially restrict membership to states. To amend Interpol constitution, there is a very specific procedural rules. If I remember correctly, we need a two-thirds majority of the General Assembly. So there is a constitutional ether that needs to take place. So all the efforts to change were unsuccessful. Interpol has circumvented the issue by passing a resolution in 2017 at the General Assembly, stating that the word country in Article 4 of its constitution should be interpreted as sovereign state. Now, that came out of the blue, and more importantly, this is a constitutional revision which has been bypassed by passing a resolution. So legally, it's quite controversial to do that, of course. So this interpretation may actually be unconstitutional because it goes against the historical interpretation, so the will of the ratio, the intention of the drafters, and it goes against other constitutional norms that are on Interpol. And we are going to debate why we went to this point and what are the legal ramifications and why this was a controversial decision. There are also practical issues. So nowadays there are in Interpol countries, and I'm using this word like Aruba, Curacao, St. Martin, which are members of Interpol. They're not universally recognized as states. So are they going to be removed from the list of countries? Are they making an exception? This was never clarified how this norm was being interpreted. So it looks it's been passed maybe for a specific purpose. We don't know. By also passing this resolution claiming that only states can become a member of Interpol, Interpol has put itself in a very uncomfortable position because the recognition of what is a state or what isn't a state, it's one of the most controversial and politicized element of public international law. Sometimes certain countries get recognition of statehood by specific countries and not by other. We can think about Kosovo. We can think about the struggle of Palestine to be recognized as a state. So the struggle of Taiwan to be recognized as a state as well. So what is a state in international law? There are specific requirements, but then we need the recognition of other states, which is a bilateral act that applies. And Interpol has put itself in a position of having to decide autonomously who is a state or not whenever they accept requests for application. Unfortunately, Interpol has other constitutional, or fortunately, Interpol has other constitutional norms, for instance, Article 3, which state the neutrality of Interpol. So Interpol cannot, by its constitution, make political, essentially entering the political arena, needs to maintain its neutrality. And this actually, it's in open contradiction between these other constitutional interpretation of Article 4. Now, another process which I think that it's not quite research, but it's also interesting, is what is the process to become a member of Interpol? This should be, I suppose, like a more clearly specified in the constitution of Interpol, but it isn't. So Article 4 gives us a very rough idea, but in the way that it's been applied, it's slightly different. So the process for an entity to become a member of Interpol is only briefly outlined in Article 4, which states that request, we have read it before, must be submitted to the Secretary General and approved by the General Assembly with a 2/3 majority. However, in practice, the requests for membership are jointly handled by the Secretary General and the Executive Committee. The Executive Committee is the committee that decides which items go into the agenda of the General Assembly. So requests may be blocked either by the Secretary General, which is what happened for Kosovo's application in 2010, or by the Executive Committee, which may refuse to add an item on the agenda. So states cannot vote on requests of membership, essentially, if the Executive Committee do not add these requests on the General Assembly. There is another article that can allow the General Assembly to put on its own items in the agenda. There are some requirements of urgency and importance. And it has been used in 1986, for instance, to independently add and vote on Brazil's membership request. So there is a way out in case there is an impasse. But now let's look at the process that led to the exclusion of Taiwan from Interpol, because I think this is very interesting because it has still repercussion nowadays, and it's still a moment in time which Interpol clearly took a side in a political dispute between China and Taiwan, and it is still keeping clearly a side. So in 1961, the Republic of China, commonly known as Taiwan, became a full member of Interpol. In May 1984, the People's Republic of China, what we commonly refer to as China, formally applied for membership in Interpol. Now, China was already a member of Interpol before the 1940s, but then it withdrew. So essentially it was a new application. When applying, the People's Republic of China requested to be recognized as the sole representative of China within the organization. The executive committee welcomed the application of China, but raised concern about the conditional acceptance, essentially. However, the executive committee caved in and decided that the item, which it's part of the process to accept requests for membership, for the following General Assembly agenda. Interpol officials at that point decided to visit Taipei to warn Taiwan of the vote, offering continuing membership to Taiwan, but only if it accepted to participate as a sub-bureau under Beijing's National Central Bureau, a proposal that actually came from China itself, as it can be implied. Taiwan found this arrangement unacceptable, so they declined. Now, this is something interesting also happened. So in order to make the request official, the People's Republic of China, which at this point in history was not a member of Interpol, prepared a draft resolution for the next General Assembly of Interpol, stipulating that a successful vote on its own membership would make it the sole representative of China in Interpol. There was some attempt, there is evidence there was some attempt of negotiation and conciliation, but nothing came out of that. So what happened is that the resolution was actually being put to a vote. Many Interpol members, there is evidence that weren't happy about this, and even the General Secretariat itself expressed doubts about the constitutionality and the legitimacy of voting on a conditional request. It was an unprecedented move at the time. Now, the People's Republic of China got accepted as a member at the second round. I remind you, needed a 2/3 majority. So the first round it didn't pass, and then at the second round it got accepted. China made it clear that it still insisted that Taiwan could remain only as a sub-bureau. Taiwan rejected, which led then to its withdrawal in 1984. Now, in 1986, we have like an official statement of the executive committee to the General Secretary of Interpol, and the task of communicating to the General Assembly that Taiwan refused to participate as a sub-bureau of China and that no alternative solutions would be pursued by Interpol. So we are in 1986 at this moment. Then from 1980s onwards, as I said, there were many attempts to clarify that countries in Article 4 could only be sovereign state. Now, what is Interpol's recent position of Taiwan? Now, since 2016, Taiwan has been trying and has been very vocal to participate in Interpol's General Assembly as an observer, which I invite you to look at the rules of procedure of the General Assembly. It's a very unambitious proposition. Observer doesn't have essentially any power. It's a very limited position inside the organization, essentially. But there's been also like international political pressure for Taiwan to actually join as a full member as well. There's been evidence that at the 87th General Assembly in Dubai in 2018, several members attempted to discuss about Taiwan, but were not allowed to do so. More recently, during a press conference related to the 90th General Assembly, so I think it was the one of 2 years ago of 2022, it was the 90th, Secretary General Jungerstock stated that Interpol's official stance of Taiwan has remained unchanged since 1984. Last year, Taiwan gave support of 60 countries, but was still not invited to the 91st General Assembly in Vienna. So this is the stance of Interpol nowadays on the issue of Taiwan. Now, this is part of a research project. I'm soon to publish a chapter which I wrote with a colleague of mine from the University of Plymouth, Luke Fisher, and we were we were making a discussion on this chapter, which I'm kind of introducing now. So in my opinion, there are in our opinion, there are three critical aspects. They highlight how the Interpol's exclusion of Taiwan appears to reflect political pressure rather than an objective application of its legal framework. Now, the exclusion of Taiwan not only risks undermining trust in Interpol's apolitical nature, which is a constitutional characteristic of Interpol, so it's not something a PR issue. It's like a constitutional requirement that Interpol is apolitical in nature. But has also significant implication for global security in the fight against crime, both in the Asian region, but also beyond, due to Taiwan significance. So what are these aspects that led us to believe that the exclusion of Taiwan was political and not a legal one? The first is that Taiwan's loss of membership did not adhere to any established constitutional procedure. It resulted from a contentious vote initiated at the insistence of the People's Republic of China, which at the time was not even a member of Interpol. So a draft resolution was prepared by an entity by a state which was not a member of Interpol and was put to a vote, which was unprecedented. Notably, Interpol itself acknowledged in a resolution adopted at the 22 General Assembly when it tasked a working group with reviewing and proposing criteria and procedures for expulsion or suspension of members to ensure transparency and consistency according to common international standards. So Interpol itself, in a way, has indirectly acknowledged that there isn't a constitutional way of excluding members of Interpol. Now, another implication that this decision was not a legal one is that Interpol violated its principle of neutrality by becoming entangled in a political dispute between China and Taiwan and effectively taking a side. And this breach of neutrality persists as Taiwan continues to be excluded from participating in the organization activities. So this is not a decision that was taken in the 80s, but this is a decision that has been confirmed and it still applies. It's something that was taken almost 4 decades ago. So it's not something that it's in the past, but it's something that's in the present. So Article 3 of Interpol Constitution, which is something that we are going to discuss even later when we're going to talk about transnational repression, states that it is strictly forbidden for the organization to undertake any intervention or activities of a political, military, religious, or racial character. Now, the last point is that the Interpol's decision to exclude Taiwan contradicts its own constitutional objectives. So the aims of Interpol are outlined in Article 2 of its constitution. So the aims of Interpol are Article 2.1, to ensure and promote the widest possible mutual assistance between all criminal police authorities within the limits of the laws existing in the different countries and in the spirit of the Universal Declaration of Human Rights. So to ensure and promote the widest possible mutual assistance between all criminal police authorities. So in order not to promote or to ensure this cooperation, it needs to be impossible. So a political disagreement of one state of Interpol, it shouldn't be something that makes this impossible, essentially. The constitutional standard should be quite high. So I thought that this was kind of like a good topic, which has kind of been, in my opinion, a little bit overlooked, but it kind of gives us a glimpse on principle of democracy inside of the organization from kind of a different aspect. This was, in my opinion, an interesting case study. So, thank you.
Julius, thank you very much. It's a very interesting topic and a great presentation. Taiwan is certainly a pressing issue, Taiwan's participation, and I'm looking forward to discussing it. I want to yield to Edward now. He was going to talk about how Interpol abuse fits into broader patterns of transnational repression. Before I do it, though, I want to just give a brief introduction into both Giulio's and Edward's work. I wasn't able to do it because we started a tiny bit late because of the technical difficulties. But Giulio is a lecturer in law at the University of Plymouth, and his research mainly focuses on transnational criminal law, human rights, international police cooperation, Interpol, and policing outer space. He has spoken on the topic at many conferences and published several articles. He has served as an expert in international police cooperation. He reviewed a report, for example, commissioned by the European Parliament regarding the activities of Interpol and the impact on human rights. And he provided an expert opinion on the legal value of an Interpol red notice for the Canadian judicial system. His publications have been cited and quoted in many academic works, as well as in official reports. One of his publications is actually quoted in a well-known case now here in the United States, El versus International Criminal Police Organization, in which the issue of Interpol's immunity was raised. We can certainly discuss that case as well, of course, if we have time. What is very important, and I highly recommend that you read this, is Giulio's doctoral dissertation assessing the past and present role of Interpol, balancing between the need of upholding global security by connecting police institutions of different countries and the need of safeguarding the rights of individuals. I'd love to talk about Giulio's and Edward's publications and their work in this area after they're done with their presentations today. Edward Lemon, he's a research assistant and professor at Bush School of Government and Public Service, Texas A&M University here in Washington, D.C. He published a very thorough and again, very interesting, a highly recommended article in the Journal of Democracy called Weaponizing Interpol in April 2019. So I hope if I made a mistake, please correct me. If not, Ed, the floor is yours.
Wonderful. Well, thank you, Yuri. And I'm going to build off what Giulio was talking about. As Yuri said, I'm not a legal scholar. I'm a scholar of international relations and political science. And so for me, what led me to be interested in Interpol was an interest in transnational repression, or the way in which authoritarian states target their populations abroad. And so Interpol is part of a broader trend we've seen towards growing transnational repression throughout the world. I'm interested to see how Interpol plays a role in that, and also more broadly how Interpol plays a role in extending the influence of authoritarian states. Speaking to what Giulio was presenting with regards to Chinese influence in Interpol, how Interpol as an international organization has become an arena for the kind of broader contestation we're seeing globally between authoritarian and democratic states and ideas. And so I'm interested in both of those different aspects. And so briefly wanted to just touch on a few themes related to how Interpol fits within transnational repression. And so transnational repression as a concept has, of course, been growing in interest for both the scholarly and policy communities. And I think that's very much a response to its growing prominence. We have a few data sets now, many of which I've been involved in building, that try and document events related to transnational repression. So these would include forced or extraordinary renditions, kidnappings, through to detentions based on Interpol red notices or diffusions or other forms of arrest requests that are transmitted bilaterally between different countries, through to more everyday forms of surveillance, harassment, some of which could be in person, others of which would be online. And so through those various different forms, we've seen a rise in transnational repression over the years. If we look at, for example, Freedom House, which has built a data set on transnational repression, they've now documented just over 1,000 cases in 100 different countries. Alex Dukalskis, who's kind of working more broadly, like I do, on themes of global authoritarianism, in his book about making the world safe for authoritarians, he documents 1,177 cases of transnational repression throughout history, of which over half occurred during the past 10 years, or the 10 years up until he published his book, so 2010 to 2019. I myself have been involved in building the largest known data set, the largest public data set on transnational repression. We were just looking at how China's been targeting Uyghurs, its Turkic Muslim population from Xinjiang, internationally. And so we documented 238 incidents between 1997 and 2014, and 6,870 incidents since 2014, or from 2014 up until we stopped collecting data in 2021. So we've really seen an explosion in the amount of transnational repression that we've seen. Why is this the case? Of course, partly this is due to the development of new digital technologies. Of course, that have facilitated kind of online digitally enabled transnational repression through social media networks, for example, but also sped up and made more efficient the way in which organizations like Interpol can transmit data now, of course, with the development of I-24/7, which was 2003. I guess you can correct me if I'm wrong. The Interpol has sped up the way in which these requests can be issued. And the second factor, of course, is the domestic developments we've seen in certain countries, the more authoritarian system that's been constructed under Xi Jinping, with the genocide against the Uyghur people and the anti-corruption campaign that, of course, was also about targeting individuals who were potential enemies of Xi Jinping's regime. The 2016 coup attempt in Turkey and the turn against the Gulenist movement that led Turkey to try and upload like 50,000 different diffusions through Interpol, the civil war in Syria. And these have both created new groups of enemies and increasing numbers of enemies for authoritarian regimes, but also created migration flows where many of these individuals have tried to relocate to safe, democratic host countries in Europe and North America and elsewhere. And I think the third factor that's led to this growing transnational oppression is the growing power of authoritarian states themselves. As we move towards a more multipolar world, many of the emergent poles, of course, are dominated by authoritarian states. And of course, these states have also increased the levels of cooperation between themselves. And so transnational oppression is on the rise. There's a number of reasons for this. Why would, in this situation, countries use Interpol, or regimes use Interpol to target their opponents? I wrote a piece in this book that I have in front of me, a little plug for this interesting collected volume that was published earlier this year edited by Dana Moss, of course, the person who really popularized and coined the term transnational repression in the scholarly community, in Cypera Furstenberg. I've been working with for a number of years on building data sets related to Central Asia. And in that chapter, I look at how autocrats use international organizations to pursue their opponents abroad. And so what I found within that study, which focuses on Central Asia, the area of my particular research, is that within their own kind of broader neighborhoods, within authoritarian states, they can rely on informal and formal bilateral cooperation. They can rely on organizations such as the Shanghai Cooperation Organization that counts Russia, China, Iran as its members, along with the Central Asian countries, Pakistan and India. They can rely on the Commonwealth of Independent States that was created in the wake of the collapse of the Soviet Union to facilitate a civilized divorce between those countries. So they have all of these multilateral and bilateral formal and informal relationships that they can leverage to successfully target individuals. But when those individuals, as they in many cases try to move beyond those jurisdictions, cross the Belarusian-Polish border, get to the United States, Interpol becomes a much more useful tool. And so those geographic patterns where we see authoritarian states really using Interpol, in particular to target individuals who've moved to democratic states, is one important reason why Interpol abuse is so significant and is such a significant challenge, particularly for democratic countries. I think a second aspect that I pick up on in the 2019 Journal of Democracy piece that Yuri mentioned is this idea of this myth that I think autocrats rely on, a myth that's perpetuated by Hollywood, right? With what was that movie called in the end? The movie with Dwayne "The Rock" Johnson going around the world like an Interpol agent trying to get people. Right? So when I looked at the language being used in the Turkish media, being used in the Chinese media, Russian media to describe those who were being pursued via Interpol, they were saying it was being pursued by Interpol, right? And I think that's an important distinction because that signals some kind of consensus that this international organization with now 196 members, there's some kind of consensus that those individuals are terrorists, are corrupt, are accused of often cases, crimes related to paedophilia or these sexual crimes. And so I think that's another important element is Interpol is really used, and those myths around Interpol are very useful for authoritarian regimes to signal, symbolically signal that the head of the Islamic Renaissance Party, the main opposition party in Tajikistan that was labeled a terrorist organization in 2015, is a terrorist, right? Because Interpol says he is. He was one of the early cases of someone who managed to use the new changes in Interpol's rules, in fact, to have his red notice removed from their databases based on his successful application for asylum in a European country. But Interpol uses, or authoritarian regimes use Interpol in that way. And I think finally, this will maybe touch into our broader conversation and discussion. They use Interpol because they can, right? Interpol, as we know, and others in the room are more qualified to talk on this than I am, for sure, has a culture, a law enforcement culture that is very permissive of abuse, right? Although there is, of course, the famous prohibition on the use of Interpol for political, ethnic, and other purposes, religious purposes, of course, we know that this is taking place. We know that this principle of sovereign equality, where each jurisdiction is viewed as being equal, despite the fact that many of these are jurisdictions in which there's more of a rule by law than a rule of law, this is something that makes Interpol readily available for abuse by authoritarian states. As we've seen increasing numbers of red notices and diffusions, Interpol has, of course, limited mechanisms to oversee and ensure that abuse is not taking place. So whether it's through willful neglect or incompetence, we know that Interpol is, of course, being made available to authoritarian states to pursue their opponents abroad. But anyway, I'll finish there because I want to get to the discussion, but very interested in hearing people's thoughts on these themes.
Thank you, Ed. Thank you very much. Great presentation. I think what you said about I think in your 2019 article you call it the present. I'll quote, the presence of dissidents on Interpol list as proof of international consensus regarding their guilt, like you said. It's really well put, because I don't know why, but several years, I can guess, several years ago, Interpol finally put on their website that they're not looking for anyone, they're not extraditing anyone, they're not arresting anyone. They actually don't have the power to do any of these things. They're really, in this regard, they're a database. So that's their main function, and they maintain that database, but they do not issue arrest warrants. They do not approve arrest warrants. They do not confirm or deny if the person is guilty or not of a crime committed, or I'm sorry, accused of. So, but nevertheless, I think that this narrative that government's abusers continue to push, that Interpol is looking for somebody, or that Interpol considers that person a criminal, is maybe unintentionally kind of promoted by the media, because despite what you see on the Interpol website, again, it explicitly states, I think that Interpol did it because there were so many misconceptions, again, pushed by the media and maybe by Hollywood as well, that they're more than they really are. Despite that fact, you can see in media publications to this day wording like, Interpol has arrested, or Interpol has detained, Interpol has issued a warrant, or there is an Interpol warrant. There is no such thing as an international arrest warrant either. But that allows these governments to use this narrative and damage the target's reputation. So another thing that that you had mentioned, I have not, unfortunately. I certainly will read this latest publication of yours in the book. I saw that it was published, but in your 2019 article, I'm sorry, yeah, in your 2019 article, you in the Journal of Democracy, you write about red notices and diffusions mostly, and rightly so. But in the past several years, and it's accurate, what you write is absolutely accurate. In the past several years, though, since your publication, governments have been abusing other requests that they can disseminate the Interpol. So it's the stolen lost travel documents database. They use other notices. They put people into the database because they claim that that they present danger or that they are persons of interest or witnesses, so forth, who they're looking for. And the problem with that is that the threshold that the government must meet to jump over to have those requests published in the Interpol database are much lower than for red notices and diffusions. So governments have learned to trick the system in that way as well. And you also rightly point out that terrorism is also used, and I believe, Julia, you also wrote about this in your dissertation, that terrorism is please correct me if I'm wrong, but I believe you mentioned as well that terrorism is used as also is a very convenient tool to put something into the Interpol database. The charge looks really scary. And there are many things that you can technically, insert into it. And there are many political opponents or otherwise targets of unlawful criminal prosecutions that have been baselessly accused of terrorism. So that is certainly a problem. Julio, I want to go back to Taiwan because that's one of my beloved topics, and it's really interesting because I think, and I think that's probably an accepted point of view, that Taiwan certainly must be a full member Interpol, even though they're trying to get into the organization as with a lower sort of status. But it's been unsuccessful in its attempts, and there are reports published about Taiwan's important role in international police cooperation, how much they've done despite the fact that they're not members and not Interpol members, how they cooperate with other countries. And these are really interesting reports. Unfortunately, I have not seen much in recent years, but back in, for example, there is a report. Just let me open it. It's called Taiwan's Marginalized Role in International Security, Paying a Price. It's January 2015. It's fairly old, but it's still a very interesting report that talks about Interpol's active participation in lawful international police cooperation. In terms of the I'm sorry. In terms of that General Assembly resolution on how Interpol defines a state, I find it also interesting because the same year, Interpol admitted Palestine and I believe Solomon Islands as members. It's incredible because I think that Taiwan, if this two countries, entities, whatever you want to call them, meet these requirements, I think Taiwan meets them as well. I mean, it's very hard to argue against it. They too have all the elements that the General Assembly outlines in this resolution. So we're talking, the elements are, I believe it's a population, a government, and capacity to enter into relations with other countries. I mean, obviously, Taiwan meets all of them, and yet they are not members of the organization. If you want to comment on it further, please go ahead. If not,
from the point of view of international law, and I'm going by memory here, this is a rule of customary international law. It comes from the Montevideo Convention, which is a convention, I don't remember if of the 1920s or the 1930s, between the American states, and it defines a state as an entity having territory, population, effective government, capacity to enter into relations. So these are the four requirements. Then it needs to be recognized. So the recognition is something that happens, and it's a bilateral act. So the United States of America will recognize Italy, Italy will recognize the United States of America. It happens on a bilateral act. there is a common consensus that when a state manages to become a member of the United Nations, then de facto it's a sovereign state at all effects. The point is that Interpol shouldn't even enter into this debate. That was the original intention of the drafter of the Constitution in 1956. They removed the word state essentially to avoid entering a discussion who is a state and who isn't. Why? Because the recognition, that's the most politicized element of public international law. And Interpol wanted to be, and was trying to be, I suppose, even at the time, apolitical in nature, wanted to be a technical effort of cooperation on matters of international policing. And so there was a wisdom in avoiding that. It's interesting that since the late 1980s, after the controversial happenings of Taiwan, there was attempted to amend the constitution, and they never succeeded. They had to circumvent that by adopting a resolution, which is a much lower threshold. It doesn't need a 2/3 majority. So yes, the point is that I don't think it's even healthy to start debating, is this a state or not for Interpol. That shouldn't be the job of Interpol. The job of Interpol is to connect let me retake Article 2 because I have a very bad memory. Sorry a second. To ensure and promote the widest possible mutual assistance between all criminal police authorities within the limits of the laws existing in different countries. So criminal police authorities between the laws existing in different countries. We're not talking about police force of specific states. So even in the aims of Interpol, the word countries was used. So I think that there was a wisdom in doing that, and I think this is actually a symptom of a problem of Interpol that is kind of caving to external pressure. The fact that they've kind of they do, which is what I was trying to say in the beginning, like these two issues look separate, but in reality they are kind of symptoms of the same sickness, probably, that there is like external influences affecting Interpol functioning and how its internal rules are applied. There is also one of the most, and I might say this as well, that there is also this idea, which I very much agree with, that there is an interest in having Interpol as large as possible because we don't want to have criminal havens in certain states. So there is a value in that. Even if some states are abusing the platform, there is still value in international police cooperation. But then we cannot have it both ways, that we are excluding some countries out of matter. So, or we make like a truly international platform and global and accept some of the risks without, but we cannot have it both ways at the point by excluding something. Because if our aim is to avoid criminal havens, then we can't at the point exclude someone from the cooperation processes. I wanted also to answer something that Edward Lemon, Edward was saying, which was very interesting to me, if I may have like a couple of minutes, about the issue whether is Interpol essentially not being wary about the issue of abuse. I think that's also like a legal issue, because by constitution of Interpol, Inter needs to maintain a neutral stance. So every time they receive a request for cooperation, they cannot come prejudice in looking at that. If the documents, they are prima facie, they are immediately like looking legitimate, the General Secretariat cannot avoid publishing the notice by saying that we distrust you as a state, so we're not going to publish this notice. They can't do that. That would go against the Article 3 of the Constitution. So it's kind of a system that on its own, it's a virtuous idea that it's a political, but then it also needs to be applied in an uncomfortable manner, and allowing states that they probably know themselves that some of the notices may be abusive, but because they need to be apolitical in nature, if the criminal documents attached are legitimate, they need to publish and hope for the best. There has been instances, which I'm sure you have seen probably, that criminal evidence has been fabricated by states to convince Interpol in publishing notices. So that's
right. No, that's a good point. And the presumption in Interpol's rules is that whatever a government submits initially is accurate. So it's sort of like the presumption of innocence, but taken, the other way. It's all upside down. I mean, Interpol has been pretty clear on that, right? That the presumption of innocence is not what they're supposed to engage in as an analysis. So in other words, it's on you as an individual who argues against the government request disseminated via Interpol's channels that the accusations are baseless. And there is a rule for that in the RPD, but a separate rule for that. But it's the presumption of innocence is not, technically speaking, is non-existent there. Except, of course, and you can, if you have a ruling or, by in international, say it's the European Court of Human Rights, or where something of that kind is brought up. But yes, the presumption that the government is right, at least initially, and the screening process, and I know we've talked about it on many occasions, a screening process within Interpol, despite all the reforms since 2017, it's still very basic. It really is. And for Interpol to engage in something more thorough in terms of pre-screening, again, before something is published in the database, it seems like, again, from the previous experience, something really drastic must happen. Like if we look at, for example, Russia, Ukraine, Interpol decided to screen all incoming diffusions from Russia, but to do that, they needed these events to happen, this really critical events to happen. Same with Afghanistan. When Taliban took over, Interpol finally decided that they need to do something and engage in a more thorough screening of what was coming in. In other words, in Turkey, that you brought up, that I believe Ed brought up this instance when Turkey tried, at least reportedly, according to the media, tried to submit, I believe it was 60,000 names at the same time or within a very short period of time into the Interpol database. The media, I remember, reported that Turkey was suspended for that, and then Interpol rushed to not retract it, I guess, argue against it and say that no, they did not suspend Turkey, that they were committed to international police cooperation and so forth. So like that attempt, if it happened, maybe it wasn't 60,000 names. Even if it was just 1,000 names, after an allegedly attempted and failed coup, still did not seem to persuade Interpol that they had to do something more than what they do on a regular basis as a general rule. If you have anything to add, please go ahead.
Yeah, I think, as I said, I think it's a matter of capacity. Obviously one option would be to outsource some of this, have expert panels, of outside experts who could view red notices. But I think, this culture of law enforcement, this culture of secrecy and lack of transparency seems to pervade the organization. It's very defensive. It's very untransparent in the way in which it operates. I think Megan Stalkup, kind of legal sociologist based in Canada, has done some interesting work on this kind of the culture of Interpol, and she embedded herself there, if I'm not mistaken, a decade or two ago. But she really writes about how that kind of law enforcement culture pervades the organization, which of course means that we do trust the other police organizations, and there does seem a bit of a kind of us versus them. We're together struggling to fight crime, whilst all of these pesky academics and human rights activists and lawyers are criticizing us for what we're doing. And I think there's a defensive kind of solidarity within the organization against that kind of outside criticism.
And it's also that we had heard from Interpol for years, right, that they had been working on improving the redress mechanism, even after the 2017 reforms, which they admittedly did significantly improved things. But again, if we compare this things to what they were before the reforms, to me, it seems like Interpol brought its redress mechanism from a Stone Age to the Middle Ages, and it stopped. So in that sense, the changes were significant, but they still nowhere close to guaranteeing what we used to as a modern democratic due process. There is no right to appeal. There is no right to a hearing, and there is no right to examine evidence that the government produces against you. I mean, just these three. And these are not the only problems, obviously. But then there was this interview by the Interpol Secretary General right before, I believe, the most recent General Assembly by Jürgen Stock, who said, I'm sorry, I'm not quoting, I'm paraphrasing, but the point was that Interpol had done, that was my understanding of what he said, Interpol had done everything it could to improve its redress mechanism. And I remember said something like, if we received any interesting ideas, we would have at least consider them or implement them. But I mean, if the lack of the right to a hearing, if a virtually complete lack of transparency are not good ideas, then I don't know. I don't know what might be. And that's when, to me, it kind of put an end to this hope that Interpol had actually been working on improving its redress mechanism as it used to claim. I mean, I was baffled by that interview. I really was. We still don't know if Interpol has a screening mechanism for incoming requests concerning people who have already been declared victims of Interpol abuse by, for example, the Commission for the Control of Interpol's files. In the one of the CCF annual reports, the Commission states that it had to deal with cases in which, after a red notice was deleted by the Commission's ruling, because it was non-compliant, the same governments were able to submit diffusions against the same individuals, which it seemed like they went through smoothly into the system. Then the diffusions were removed, and then the same governments abused the stolen and lost travel documents database, which to me suggests that, at least at that time, there was no, I'm not an IT person, but I would assume it would probably require a pretty simple code to match incoming names with the names of those who have already been declared victims of unlawful government requests disseminated via Interpol's channels. And yet it seems like that mechanism did not exist at the time, and we still don't know if it has been implemented. So in other words, Interpol had failed to enforce its own decisions. Then the redress mechanism just doesn't make sense to me. So yes, I mean, it's unfortunately, and I believe, and I'm sorry, I don't remember if it was you, Ed, or you, Julie, or both of you mentioning this in your publications, that the refugee policy that has been in place, I believe, since 2014. Several years later, it was finally approved by the General Assembly. Initially, it was adopted by the Executive Committee. When the General Assembly adopted this resolution, approving the policy, first of all, the text of the policy is not in the resolution, which doesn't make it, somehow it's a mystery. Like, I've received letters from the CCF in which it removed my clients based on the refugee policy, but the refugee policy itself, its text, was redacted. I mean, interestingly enough, everybody knows what it says. So thanks to fair trials, I believe they still have the text on their website, but somehow it's not, it wasn't on the Interpol website. And what's more, I think, worrisome is that the resolution, the General Assembly's resolution approving the policy, in it, the General Assembly was much more concerned. I believe that, I think you mentioned that. I'm sorry if I'm mistaken. Please correct me if I'm wrong. But the General Assembly was more worried about people with refugee status abusing refugee status, as opposed to non-democratic regimes tracking down refugees through Interpol. So I think it's interesting. And Giulio, you in your dissertation, and again, please correct me if I'm wrong, it's my understanding, you were trying to find a balance between international police cooperation and human rights. And I guess that's the topic that we all trying to comprehend and achieve something there. So what do you think the balance, if you can sum it up, the balance might be? I mean, you suggested, I believe you suggested, again, please correct me if I'm wrong, that's my understanding, you suggested, you call them surgical interventions to improve the existing system, right? So what can that be, in your opinion?
Well, I think you said something very interesting before, and I would like to use it as a segue. You told how the system went from being the Stone Ages to the Middle Ages, and it was a funny analogy. But I would like to point out that the system of notices, it's not something that was invented in the 2020s. It's something that was in an infancy form, being present already at the time of the International Criminal Police Commission. It's something that comes out of Edgar Hoover. It imported the system of the wanted poster from the US and say that it was a good idea to implement it on Interpol as well. The system of the wanted poster in the US worked inside the territory of a state. So it went to its own scrutiny and system, and then it was exported on an international platform. Now, at the time, human rights did not exist. Nowadays, individuals, there is the concept that they are not just objects of international law, but they have rights in international law. We have human rights independently of where we are born from. This wasn't the concept that existed at the time when Interpol was built. And the system of notices, which is something that you were talking before, it seems that there is kind of a presumption of that the government is right, and then it's up to the individuals to prove that the government is actually wrong. Well, this comes because the system was developed in a time where human rights weren't there, so states essentially could treat their citizens as they pleased. There was allowed. The idea of human rights is something that came from 1948 onwards. There was some idea brewing, but it becomes right, well developed Universal Declaration on Human Rights, and then all the subsequent developments. So in a way, Interpol is trying to catch up with something that was already there, and now there is a need to bring it to a more fair system and to a more legal development system. The surgical intervention that I was talking about, I think I was referring to the fact how states and perhaps like this was an article that was written in 2016, so now it's showing a little bit of its age, I have to say. But it was a time when the issue of double arrest, according to red notices, was very common. So individuals would become arrested in one country. The judicial court would ascertain that the notice, there wasn't really much teeth to it, so they would release the person would travel into another country, would get arrested immediately again. And there was this system, which was system of addenda in Interpol, which it's specified in an obscure resolution of how Interpol has actually the duty of making notices layered. And I said that this was actually a good idea, so that once there is a judicial decision, when a notice pops up in the system, there should also be like immediate information that the person was already released in another country. So kind of depower the notice itself. But that probably goes against the interest of Interpol. So there is this system, but it's unclear whether it was used at the time. So I was saying that using this system more consistently could improve it. I wasn't saying that was the solution to all the malaise, but I would say that this was like a good first step to make the system more acceptable. So yes, this was, I think, the surgical intervention referred to use the system. Then Interpol, it's very, I have to say that, and you are talking something, and I'm going to bring you this example, because sometimes Interpol lacks, we say it lacks transparency, but sometimes also lacks clarity, because when we look at official declaration and then at the legal frameworks, sometimes there are incongruences. For instance, you are claiming right that diffusion systems now they get monitored, for instance, every time they, in the context of Russia post-Ukraine war, there was actually this huge statement. But if we look at the definition of diffusion, so from Article 114 on the rules on the processing of data, diffusion means any request for international cooperation or any international alert from a national central bureau, for instance, Russia, or an international entity sent directly to one or several national bureaus or to one or several international entities and simultaneously recorded in a police database of the organization. So by an act of a state of sending a diffusion to either another national central bureau, there's two ramifications. First, there is like a communication to the other national central bureau, and then it gets recorded at the same time. So is the scrutiny on both of them or just on the recording of the database? That's something that has never been clarified to me, and it's something that I'm still struggling to understand how Interpol applies that. Because essentially there's two wires, one that goes to the central system and one that goes essentially like almost like a letter to the state. So what is that it's been here screened? The fact that it's been recorded or the fact that it's sent or both of them. So sometimes Interpol does lack clarity and unfortunately there are some misunderstanding. I'm also thinking about the system of the so very famous legal review, Article 86 of the Red Notices, so that the General Secretariat has the duty of carrying out a legal review, making sure that it complies with Article 2 and 3 of the Constitutions. There is a legal requirement for any sort of data in the database that the General Secretariat needs to carry out. So why do you put it into different sectors? So are you not using in the other one? So sometimes there is, I think there are some problems also with the drafting of the legal documents of Interpol. If we look carefully, we can really start to pinpoint many incongruences. Yeah.
Absolutely, yeah. There's certainly I can say as an attorney who practices in this area that I've been confused on a number of occasions reading Interpol's rules and rulings, and that's on top of several very important provisions in the rules on data processing that we often use. Basically, one of the two main documents that we use in defending the victims of Interpol abuse, the Constitution and the RPD. There are several important provisions that still haven't been clarified by Interpol, like, for example, the private disputes provision. I'm personally curious if hostile corporate takeovers using corrupt criminal prosecutions fall under that definition. I still don't know if this is the case. I don't know if Interpol does. I think it would make sense because it's a private dispute that's been illegally transformed into a criminal matter to use a criminal, and that happens all the time in the former Soviet Union, in other non-democratic countries where corrupt government officials launch a criminal investigation, charge somebody at the request of a more, let's call it, powerful, financially powerful or otherwise actor who wants to take over that particular business. And of course, if you are in jail or if you're on the Interpol wanted list, it's much easier to, let's call it, negotiate with you. So again, there is still no word from Interpol on that. One of the recent decision excerpts touches a tiny bit on private disputes, but there is still no definition in it. Even the refugee and asylum seeker policy says that it applies in general. There is this wording in it, and in general is like, what does that mean? So Interpol often, I think that that's probably done intentionally, that Interpol leaves some sort of like a leeway for itself, an exit strategy in case it needs to make an exception. Although the refugee policy, I think, has been applied fairly consistently, Interpol did rule that eventually, it was several years ago after they adopted the policy, that if you file a request for deletion after you become a citizen of the country that granted you asylum, the refugee asylum seeker policy does not apply to you anymore. That means that you have to argue your case, let's call it, to the full extent based on Article 3, 2, or otherwise, and which is, of course, much harder. And I assume Interpol was based this approach on the Convention on Status of Refugees, but which says that you cease to be a refugee after you become a citizen. That makes sense from the standpoint of that convention, but not from Interpol's sort of how Interpol functions, because the point I think here is why you became a refugee, right? The fact that you became a refugee because of that criminal prosecution. So why Interpol decided to strictly follow the convention in this regard, I think that wasn't a well-reasoned decision in my opinion. Ed, I want to quote again you because I think it's a great way you put it. You said that in your article you say that to abuse Interpol is to raise the cost of dissent. That is a great way to put it. I mean, it certainly is, because if you decide to speak up, for example, if you're a political opponent, the problems that you're going to face after you end up on the Interpol wanted list, let's use a terminology, even if it's legally wrong because it's so popular, is I mean, it's really costly. It really
Yeah,
is.
no, I think you're speaking to kind of broadly transnational repression. Repression in general, right, is a tool of power, right? It's about trying to influence people to change their behavior. And so, both directly and indirectly, right? You can either directly punish someone for speaking out after they leave the country, but you're also signaling more broadly to others in the diaspora community the consequences of um, voicing opposition after exit, or voicing independent thoughts, or even in the case of the Uyghurs, even just being part of a community that is, by virtue of its ethnicity and religion, being persecuted en masse. So it's not even related to particular behaviors in that case, which I think is an interesting distinction. And so, yeah, I think Interpol, because of its reputation, because it's an international organization, as we've already talked about, is a particular tool for discrediting opposition, and a useful tool for targeting people who've managed to escape to more democratic contexts. And so, I think that's kind of how it fits more broadly within transnational repression. But of course, it's also an area where there is a greater opportunity for countries that have the will to do so to try and reform and insulate their domestic legal systems against Interpol abuse, as we've seen to some degree in the United States with the FRAP Act, for example, or work together within Interpol to try and enact reforms. So that's why I think it's an interesting case study. Of course, it's interesting to look at things like the Shanghai Cooperation Organization and Commonwealth of Independent States, but of course, given they're completely, almost in the case of the Shanghai Cooperation Organization, dominated by authoritarian states, of course, there is no real opportunity for changes within those organizations. So I think that's why Interpol is an interesting case study, because there is some opportunity to try to make the changes, although it's an uphill struggle, as we've been discussing.
Yes, it certainly is, because I believe there was a study several years ago that the majority of Interpol member countries are non-democratic. So, so to even the fact that the reforms of 2017 were carried out is, I think, is close to a miracle. But it's also like, going back to one of the things that you just mentioned. The problem is that even if you end up in a democratic country, you request asylum or whatever, it's still a big problem, because democratic countries often inadvertently become sort of like aiders and abettors of Interpol abusers. Our laws, even here in the United States, I mean, people end up, I've handled cases like this. I've had clients who request asylum. They openly, they came, request asylum, explained that they being unlawfully prosecuted, and they were put in a detention facility. Some of them spent months and years in there without committing any crime here in the United States. It's plus, of course, immigration courts are clogged, so it takes time for them to explain their case and get out on bail if that happens at all. It's a huge problem, and even the Transnational Repression Accountability Prevention Act that became law just fairly recently, unfortunately, doesn't really, in my opinion, did not change anything really, because it sort of what it has in it is what we already had before. In other words, this approach that well, red notice on its own should not be enough to arrest somebody or extradite or move from the country. But that was the case before that. The problem is that this requirement is easy to meet because the government can simply add something to the red notice, and a communication between them and the foreign government, and argue that the person should be removed from the country. So it's still a huge issue, and without reforming Interpol and without reforming national laws to address Interpol's real role in all of this, and educating people, especially government officials, what Interpol actually is, that it's not a body that adjudicates criminal charges, but it's, again, in so many ways just a database. I think it'll probably take us time because it's still out there, this wrong notions, despite all these years that we've been trying to explain it, and despite our publication and so forth. This has been a very interesting discussion. I greatly appreciate it. Thank you very, very much for joining it. If you want to add something, please go ahead. To the audience, if you have any questions, as always, please feel free to email, and I'll gladly share them with the panelists if they, of course, they allow. And again, I encourage you to read Julio's and Edward's publications. They are, in my opinion, invaluable, including for lawyers, not just scholars and the general public, but for lawyers as well, because in my opinion, you get a great perspective of the entire sort of universe of Interpol and its flaws and how it works and so forth. So Julian and Ed, if you want to add something, please go ahead.
Sure. I think just briefly to finish on, I think it'll be interesting to see, at least within the context of the United States, with the new administration coming in, a new administration, of course, that has been elected in part on an anti-migration platform. And so obviously there's a great danger that despite the existence of the TRAP Act, we may well see red notices issued against individuals, particularly accused of terrorism from places like Central Asia. Even if those are politically motivated charges, we could easily see those immigration in the push to potentially deport the millions of people that the administration envisages. Certainly we could see Interpol playing a role within that. And I think we also could see that within Europe, and we're already seeing, not directly through Interpol, but we're seeing, for example, recent cases of various individuals from Central Asia being deported from Germany and Austria, who were members of opposition groups accused of terrorism in their home countries, being deported and, unsurprisingly, unfortunately, being arrested upon arrival and given long jail sentences despite the protestations from the international community. So as we see this rising anti-migration sentiment in the West, I think Interpol could well play a role in facilitating the return of individuals who will then ultimately face mistreatment, torture, imprisonment, and so on and so forth. So I think that's maybe not an optimistic note to end on, but certainly something.
That's very important note. Do you want to add anything, Julia?
Well, I think Edward and you both say like a good point that the problem it's global, so some of the solutions can be local. So states, they do have a duties in implementing domestic regulation that make sure that the way that they deal with Interpol, it's in a healthy manner, and even with skepticism about the way that Interpol works. So it's essentially, it's a database. There is actually a fair description, is a synthetic but a fair one. However, the problem it's global, it's not local. So the source of issue is how Interpol has been developed. So the solution needs to be global ultimately. Also because states can protect their own citizens only in their territorial jurisdictions. Eventually they can go out of their territorial jurisdiction, and then it becomes impossible. Even if we look at this from a parochial level, from a state point of view, there is interest that this gets solved at the global level as well. Yeah. So in my opinion, it's important that a global solution to Interpol is found and not just a local one.
Yeah, and I agree. It's impossible to fix Interpol just on several nations level. It's impossible. The TRAP Act, which is really, I believe at this point, the only statute, the only law probably on the planet that it kind of recognizes the issue. Well, the European Union has had these discussions as well, but the TRAP Act, one of the things that you can find in it is that the United States government is supposed to promote all these different reforms, but without the consent of the majority of member countries, this is not going to go anywhere, in my opinion. And in terms of potentially coming repressions, what Ed just mentioned as well, I think it's important to remember that there is such thing as a preemptive request that you can file with Interpol. That is warning the organization in advance, or if you're not sure if you're in a database, that an incoming abusive request is possible. But the thing is that, again, these preemptive requests are nowhere recognized in Interpol's rules. There is just, under the rules, there is no such thing, legally speaking, although Interpol has admitted that they receive them. But what happens is that, from time to time, they don't get adjudicated until the actual government request is actually received. So if you file a preemptive request, you will most likely not hear from Interpol until you're actually in the database, or maybe Interpol blocks it. But again, it's maybe. There is no guarantee that they will do it before they notify you that you are in the database, or that the request has arrived. It's more likely that it will actually enter the database, at which point it might be late because you might get arrested. So unfortunately, there is still no mechanism to warn the organization in a meaningful way to prevent abuse before it happens. It still doesn't exist. And that's very unfortunate. Again, thanks a lot this is a great discussion. I hope we do it again. And I hope you enjoyed it too. And again, to the audience, please feel free to send us questions. I'll happily forward them to the panelists. Thank you very much, Dr. Lemon and Dr. Kulkara, for the great discussion. And again, let's do it again sometime.
Very interesting discussion. Great to be here.
Thank you very much.